Welcome to Mentoring with the Masters. In this segment, Ava Doppelt is going to be speaking with you about tips for litigating in federal court.
Good morning. I'm delighted to be here today. My name is Ava Doppelt, and I'm a partner at Allen, Dyer, Doppelt, Milbrath Gilchrist, an intellectual property law firm in Orlando. I'm going to give you some tips for litigating in federal court because that's mostly what we do. But my tips are going to be relate primarily to civil cases, and we're talking about federal courts in Florida. So there's a lot to know, and the more comfortable you get in federal court, the more you will be comfortable. But I just want to start out by saying it isn't state court, and there are differences. Some of those differences really are differences in emphasis and degree. I'm not going to say that we don't have rules in state court, but federal court is different, and that's what I want to talk to you about. Let me give you three primary areas of difference. Federal court is rule intensive. You must know the rules, and there are a lot of different kinds of rules you should look at. Number two, federal court is heavily case managed. That means it's not an open-ended sort of thing. From the very beginning, you know what your deadlines are, you know when the trial is going to be, and you plan accordingly. And number three, there is the emphasis in federal court is on written advocacy. That's not to say you don't show up and argue in front of the judge or the jury when the time comes, but the primary emphasis in federal court is on written advocacy, and you should make it as excellent as you can. Let me give you a few. I'm going to go through and give you 10 things to remember about those three areas, and let me go through and tell you them. First, under the issue about rules, read the rules. That means read the federal rules to make sure there's not a rule that addresses your particular issue. Read it through from beginning to end, and also make sure you're reading the very newest version of the rules because, for instance, just as an example, December 1st, 2013, there were changes in the rules, and if you didn't know that, you might not do the right thing when you're getting a subpoena issued under Rule 45. Read the local rules, and we have 3 districts in Florida, and all of them have different local rules, and they change all the time too. One of the most important things you can do, and this is the second point, look at the website for the court. The court, all 3 of the courts and the bankruptcy courts as well, have excellent websites with incredible amounts of information that you really must know. Under that, see what you need to know for your own type of case and your judge and magistrate. Many of the judges and magistrates have their own individual pages, and those pages tell you how they want their sometimes their briefs, their hearings, their telephonic hearings. They have their own rules, and you don't want to be ignorant of those. Let's see, number 3, look at the rules for the courthouse. Make sure you know where it is and how to get there. Make sure you know what you can bring in and what you can't bring in, and if you need something like your laptop for a hearing, make sure you know if you need to get an order to bring it in. Federal court is a little more formal than state court in most of our districts, and you can't just necessarily walk in with your cell phone or your laptop. And know the rules of how the court works. You need to, for instance, bring a photo ID to get into the courthouse. You don't want to show up without it. Know the technology of the courtroom. Know the rules for admission to court. And maintain those rules. You must renew your admission every couple of years or you will not be able to appear. Know the rules for electronic filing, which we have, of course, in every one of our courts. Case management, that is something that you and your opponent do with the judge. And you must make sure to follow those rules. These are not flexible rules particularly. These are solid deadlines and must be observed, and they can only be changed with the judge's approval. Don't assume that just because you and your opponent agree on some kind of change in the deadline, that's what's going to happen. And finally, write well, write carefully, and proofread everything you write. That means you. That doesn't mean just your associate, doesn't mean just your assistant. You need to look at everything you file before you file it. Nothing says to the judge that you don't care about your motion or your pleading than a sloppy pleading. And that means you need to follow all the rules about font size, margins, caption style. Those are in the federal rules, those are in the local rules, and you need to be careful to make sure you do that. And finally, I'm going to just say, when I was asking some people about what I should tell you today, I was directed to the website of a bankruptcy judge, Michael Williamson, who has posted on his website, he's in the Middle District in Tampa, the 3-3-3 rule for writing briefs. And that's 3 pages, 3 cases, and 3 minutes. I commend you to look at that, because what every judge has said when asked about people's writing is keep it short, keep it concise, and keep it accurate. Thank you, and thank you so much for having me here today. Good luck in federal court.